All right, listen up. Today we're inside a plea deadline courtroom where a single caveat turns what looks like a tidy deal into a ticking time bomb. We've got a defendant facing serious financial counts, a state demanding nearly $300,000 in restitution, and a judge weighing deferred adjudication versus life-range exposure. Stay with me. There are twists about timing, money, and one tiny stamp that changes everything.
Morning.
Good morning.
Thank you for dressing purpley for court. So let me see. All right, so discovery, was that completed?
Yes, Your Honor.
All right, and today is the plea deadline date. So is this going to be a jury trial or have you all reached an agreement?
We have reached an agreement, Judge. There's one caveat that
Quick legal check. When counsel says, there's one caveat, that's not small talk, it's a red flag. In practice, that caveat usually signals a condition, restitution, timing, or sentencing mechanics that can make or break the deal. Think like this. A signed plea without resolved restitution is a promise with a deadline. Would you accept a deal today knowing a large financial contingency could still collapse it later?
explained to the court.
Yes.
We're in agreement with all the terms. It's been a written plea agreement. We've gone over it with Mr. Lunsford. We do have an agreement. One of the things that the state wants to accomplish prior to the plea is restitution up front. The state, and I don't want to speak for them, but my understanding is they need a little time not only to identify the specific recipients of the restitution by name, addresses, who the check should be made out to, and the amount. It's a substantial amount of money, and we are able to pay that before sentencing. So I would suggest perhaps 30 days to get those numbers done so that we can present the agreement to the court.
This restitution discussion is huge. The state wants the full amount identified and paid before sentencing. That means names, addresses, exact figures, no vague promises. Practically, the judge setting sentencing in 30 days but holding a restitution hearing first protects victims but also forces defense to scramble cash flow and paperwork. Audience question: how often do you think defendants can actually produce large sums in that window?
Let me make a suggestion. I would suggest that you all do the plea today, and I will set it in 30 days for sentencing. And then if for some reason and it will be set for a restitution hearing before the sentencing. And then if there's an objection to the restitution, if there's an issue with the restitution, we can handle it then.
I have no, part of the plea bargain is that it would be paid up front. So as long as the before sentence is imposed,
Yes.
yeah, then that'd be acceptable to the state.
All right.
Yes.
So then that way, once I'll take the plea today, the sentencing would not occur today. And I'm assuming there's no need for a PSI or TAP evaluation, or is there a need for that?
I think there is, Judge, because some of the terms and conditions, there are going to be things left up to the court's discretion. And
all right. Well, what I can tell you is, sorry to interrupt, but what I can tell you is just to cut through things, a PSI is going to take 8 to 12 weeks. So we can enter the plea today, and then it'll be 8 to 12 weeks. That'll give everybody plenty of chances to get the restitution amount, and you all can confer off docket. Is that good for everyone?
That's fine with the state.
Yes.
All right. So if you guys will get the plea paperwork ready, I'll take the plea, and then we'll set it for a sentencing. What date would that be on, Ms. Ferguson? Well, no, it's going to be a PSI and TAP evaluation, because that will give you more time with a PSI and TAP.
Yes.
I can do it. So it'll be October 20th. And what I can tell you is PSI and TAP, those are two completely different things. So they're going to be two completely different dates for you to see probation. So make sure you meet all of those dates.
Yes, ma'am.
So October 20th, is that good for everyone?
Judge, I have a federal trial that day, but I don't think it's going to go. If we're a couple of weeks out, that looks hard, then I'll talk.
Okay. All right. So we'll set it for October 20th, and I'll wait for you all to do the plea paperwork. Once you've completed that, just let them know and we'll take it out.
Thank you, Judge.
All right. Thank you. Who else? All right. Court is going on the record. Court is calling 2025 CR 1023 State versus Mark Lunsford. Can I have parties announced?
Austin Stout for the state.
San Antonio and Sam Log from Schmucks.
And are you Mr. Lunsford?
Yes, Your Honor.
Counsel, have you received all discovery and did you review it with your client? Court will find that the state is in compliance with discovery. Mr. Lunsford, did you review the application for deferred adjudication or community supervision with your attorneys?
Yes, Your Honor.
Did you understand it and sign it?
Yes, Your Honor.
Did you review the true bill of indictment with your attorney?
Yes, Your Honor.
Did you understand it?
Yes, sir.
Counsels, do you waive the reading of the indictment?
We do, Your Honor.
State, are you proceeding on the indictment as presented?
Yes, Your Honor, except the state does have a motion to waive counts 2 through 55 and proceed only on count 1.
Any objections? Did you review the document entitled Court Admonishments with your attorneys? Did you understand it and sign it in all the appropriate places?
Defendants accept plea bargains. Trials are a binary roulette wheel where a conviction could cost you decades. The plea gives certainty, but at what price? If you were in his shoes, would you accept a fixed deal that likely limits exposure, or gamble on a trial that could mean freedom or permanent confinement?
Yes, Your Honor.
Did you understand you're charged with money laundering? Everyone, please whisper. Did you understand you're charged with the offense of money laundering less than $300,000 as a first-degree felony? Range of punishment is anywhere from 5 to 99 years in life and up to a $10,000 fine. If you have a plea with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Do you understand?
Yes, Your Honor.
You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses. The state would call in the right to remain silent. Did you understand by entering this plea, you were giving up those rights?
Yes, Your Honor.
And did you intend to give up those rights and enter into a plea in this case? Did you understand if the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court could find you guilty and sentence you up to life in prison and up to a $10,000 fine?
Yes, Your Honor.
Counsel, has your client been able to provide you with any defenses?
We discussed the defenses with him, Your Honor.
All right. Do you believe he has a rational as well as a factual understanding of the charges against him? Do you believe he's currently competent and was legally sane at the time of the offense? Mr. Lunsford, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No.
Anyone promised you anything other than the plea?
No.
Are you satisfied with the way you've been represented?
Yes, Your Honor.
Did you understand if you're not a United States citizen, by entering into this plea bargain agreement, you can be deported, not allowed naturalization or re-entry into the United States?
Yes, Your Honor.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorneys? Did you understand it?
Yes, Your Honor.
According to the plea bargain agreement, the state is proceeding on count 1. They're asking that your punishment be assessed at 10 years in the prison. There's a $10,000 fine. State is opposed to your application for deferred adjudication. There's to be restitution in the amount of $297,276.34. And you will not accept or maintain employment in any position involving the handling of financial transactions. Counsel, could you all check the box here and
Yes, sir.
initial? Did you understand that to be the plea?
Sure.
Defense, is that the plea?
With the caveat that the state was going to recommend probation. Thank you.
No, they recommend probation, but they're opposed to the deferred.
Yes, ma'am, you just.
Sorry.
You said they're opposed to defer.
All right. So did you understand that to be the plea?
Yes, Your
Do you understand that the state is opposed to your application for deferred, but they are recommending community supervision?
Honor. Yes, sir.
So do you understand if the court does not grant your application for deferred adjudication, but if the court were to grant your application for community supervision, then the court will have followed your plea bargain agreement? Do you understand? All right. Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places? Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes.
Counsel, are there any such motions?
No.
Outside the agreement, the state is recommending that your community supervision be for a term of 10 years. There be 200 hours of community service restitution, a cap of 60 days in the Bexar County Jail, no contact with the complainants listed, and felony anti-theft course and MRT. Did you understand those are recommendations from the state and the court does not have to follow those recommendations? Then to count 1, how do you plead? Guilty, not guilty, or no contest? I'm sorry?
No contest.
State, any evidence?
The state is offering State's Exhibit 1 and all attachments. And Your Honor, I just want to clarify for the record that count 1 is first degree felony, but it is for money laundering over $300,000, not less than.
All right, thank you. I think what do you call it? The sign is incorrect. You know, when they do the sign, the less than sign and the more than sign. All right. Did you review the document entitled Waiver and Consent to Stipulation of Testimony and Stipulations with your attorney?
Sure.
Did you understand it and sign it in all the appropriate places?
Yes,
And counsel, I'm assuming you have no objections to the stipulations being entered?
we do not, Your Honor.
All right. Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent? Did you understand that today the state would be presenting evidence in the form of witnesses' statements and police reports? But most importantly, there'll be no live testimony. Did you understand? Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence State's Exhibits 1 and attachments, and the court will review the same. All right, there's a stamp over the discovery.
The judge just deferred a finding of guilt while concluding there's sufficient evidence. That's deferred adjudication in action. It's effectively press pause on a conviction, comply with conditions and avoid a final guilty verdict. Fail and the conviction snaps back. Small procedural stuff, like a torn exhibit or a stamped page, can slow things down, but substance matters. Compliance, restitution, and probation terms will decide whether the defendant walks away or faces the original range.
I saw that too, Judge, a postage stamp that made its way into the document. I wasn't sure what that was.
So I'm not able to read that. If I lift it, it tears.
I can get another copy, Your Honor. It's going to take me a little while.
All right, no problem.
Okay.
So Mr. Lunsford, what's taking the court a while is that because this is submitted to me, I have to find that there's sufficient evidence to find you guilty. So I have to do my math to make sure this adds up. All right. All right. After reviewing State's Exhibits 1 and attachments, the court will find there's sufficient evidence to find you guilty. Court will defer finding of guilt as you've applied for deferred adjudication. We'll come back here for sentencing on October 20th. Your court date will be at 9 a.m. I will base my decision upon any evidence that's presented.
Sure.
All right. Anything else before we go off the record?
No.
All right. Once you sign the reset form and speak with probation, you'll be excused. All right. Thank you.
Thank you, Your Honor.
Thank you.
Your Honor.
Mark.
Thank you. But the one time I did roll my R, everything just went haywire. So I don't think the universe was expecting it. All right. So today is plea deadline date.
Yes, Your Honor. So we were recently hired on this case,
Mhm.
just a couple days ago. We still need to go through the discovery, and Ms. Laraga has informed me that she has previous experience at the mental health court. We need to explore that also, if we could. So if we could get an extension on this plea deadline, we'd appreciate that.
All right. Who's the prosecutor on this case? Shakira Laraga? Right. Did you confer with the state?
Yes, just briefly, Your Honor, just to let them know that we've been previously, just recently retained on the case. So we need to evaluate the discovery.
All right. So today is plea deadline date for them. She's previously been in a treatment court in the county court. And the last time we were here with this, there was supposed to be a consideration of the fact that she was in a treatment court.
Okay. We were just hired a couple days ago. I didn't realize that's been previously brought up to the state.
So, Ms. Ferguson, set this for the second week in September, and that will be your plea deadline date.
Thank you, Your Honor.
Thank you, Judge. What date?
Yeah.
All right, September 8th. Thank you for dressing appropriately for court. All right, just have a seat and your attorney will bring your reset form.
Thank you, Your Honor.
You too. Have a great day. All right. Yes.
I believe you had a discovery setting. The very first initial setting was a discovery setting. At that
Yes.
setting, we got a offer from the state that was a time release. We conveyed that offer. I believe we have received all discovery. I've tendered a discovery acknowledgement to the courts. And I believe the client wanted to address the court, but he formally rejects the offer.
All right, so do you want a jury trial or a bench trial?
Ma'am, look, I feel like I'm being coerced into signing for something that.
Now, here's the thing. Let me explain the process to you. And I want you to hear me and internalize what I'm saying. So anytime somebody is charged with a criminal offense, once it works its way to the DA's office, they'll review it. They may take it to the grand jury. Once a grand jury indicts a case, which doesn't mean anything, it doesn't mean you're guilty. It's just telling what you're charged with. It gets assigned to a court. And then you get assigned an attorney, and you're probably assigned an attorney before it's even indicted. Then your attorney will make sure that they have all of the discovery. So what is the discovery? The discovery is usually everything that the state says they have in order to prove that you committed this offense beyond a reasonable doubt. That's the way they look at it. That's the way they say, yep, we have enough evidence. In this court, I take it a step further. Once your attorney has told me that they've received all of the discovery, I make sure that the state tenders an offer. Now, the state's offer can be whatever they think whatever they want it to be. They're supposed to be seeking justice. That's what it says in the code. So whatever they offer you, that's what they're offering you. Your attorney will present that offer to you. You can say, I'm not accepting that, which is called a rejection. Or either you can say, I want to accept this, but I will accept this. And then that's called a counter offer. Your attorney is ethically required to give that counter offer to the state. And the state can either say, nope, we're not doing that. The only thing we're offering you is what we previously offered you. Then you have a choice to make. Your choice is either you're going to accept that offer, or either you're going to go to trial or not. Either you're going to do a jury trial or a bench trial. So railroading, whatever you feel railroading is, if you feel railroading is the state is not making an offer that you find acceptable, then to you, that's railroading. But they make their offer, and then once they make their offer, you have choices to make. So if you want a jury trial, and this court will give you a jury trial. If you want a bench trial, a lot of people think that they get to determine, yeah, I want a bench trial, therefore I get one. But the state has to agree also and say, it's okay for you to have a bench trial. What a bench trial is that I or the judge who's sitting here will hear whatever evidence is presented and make a decision on whether you're guilty or not guilty. Jury trial, there'll be 12 people sitting in the box, 12 random people, right? They'll sit in the box. The state will present their evidence to that jury, or either to the court if it's a bench trial. They'll do that by calling witnesses. Witnesses will come and testify. Hypothetically, and normally, this is what usually happens. The state has to prove that it happened in Bexar County, because if it didn't happen in Bexar County, then I don't have any jurisdiction. They usually have to prove an on or about date, and they do on or about date, so you'll know we're talking about on or about this date. This is when we're saying it happened. If it's a robbery, guess what? Complainant will come in and complainant will say certain items of value were taken from me without my consent, which means I didn't give this person permission to take my things. This person took my things. And usually a robbery involves some type of physical force. You know, if somebody is walking around with a purse and you snatch their purse, maybe that's a theft of a person, but it could potentially also be a robbery. It just depends on the way it's charged. So that's what the state has approved if it's a robbery case. If it were a drug case, they would have to bring in a chemist to say, yes, these are drugs and these are illegal substances. And then somebody would have to prove that you're the person who possessed the drugs or had care, custody, and control of it. So that's where we are. So if you are not going to come to an agreement with the state, then your next setting is going to be a jury trial date. And you will be brought over dressed in whatever clothing you have at the jail. If you wish to be brought in any other civilian clothing other than what you have at the jail, you'll need to sign a release so clothing can be brought to you. So do you want a jury trial or a bench trial, or are you reaching an agreement with the state?
The reason why I don't want to take what the state is offering me because it's I don't think prison and
Here's the thing. Let me just tell you, whatever the state is offering you, I'm not involved in what their offer is. But what I can tell you is, if you look over in that box, I guarantee you, nobody in that box will raise their hand and say that they think prison is right for them. I've had people, when I was a defense attorney and when I was a prosecutor, they would be charged with murder. They'd be like, prison's not the place for me. Nobody thinks prison is the place for them. You may once every 200 cases have somebody who'll say, yeah, I deserve to go to prison for this. But normally people don't say that. So I don't need to hear about your negotiations with the state because ethically, I'm not supposed to hear about that.
They're not even trying to hear me. He's not even trying to hear me. That's why I wanted to dismiss.
Okay, so state, who's the state on this case with Jacob?
I confer with Jason.
All right, Jason. All right, Mr. Andrade is informing the court that he wants a dismissal. Are you going to dismiss this case?
No, I'm not saying to dismiss the case.
All right, so he wants something other than what you're offering him. Are you intending to offer something other than what you've already offered?
It's just the case that we discussed. Okay, yes, something. But after conferring, no, Judge, that's the offer.
All right, so he's saying he's not going to change the offer that he has made.
In fact, Judge, just sorry to interrupt you.
No.
That would be today only offer since
All
would be
And
changing.
that's how I feel in track. Like,
All right,
I feel like I got an ultimatum. I feel like if I hired another lawyer, I have a better chance to, get a drug program because the whole reason why I'm not running from what I did. I
wouldn't seek further, but don't admit any guilt. Just please don't say something. Your Honor, we were here on a prior setting earlier this week. He had some time to think about this. I know Jason is leaving.
so today is the day you make your decision. If you don't want to accept the offer, then it's going to jury trial or either bench trial. So you can sit in the box and then I'll bring you back up at 10:30. And you need to let the court know whether you're accepting, if you've reached an agreement or whether you're going to jury trial. Those are your options.
Okay.
All right, thank you.
Discovery wise, we're fine, Judge. My client wants to replace me with different counsel. He's not cooperative with me. He has suggestions which I disagree with. And he's got a pro se motion in his hand wanting to replace me as counsel.
All right, so are you going to hire your own attorney?
I was seeing it up in somebody different from me.
No, this is your attorney. And so here's the thing. You can either talk to your attorney or not talk to your attorney.
It's not that me not wanting to talk to my attorney. He's been given certain types of evidence that he's not willing to share with the DA, messages, things that have happened to my wife.
Let me ask you something. Here's the thing. Maybe if he is not sharing something with the prosecutor, maybe it may be because it's in your best interest that it not be shared. So I don't know anyone. This has to be the only profession where people get an attorney and they think that we have no knowledge, that all we're doing is talking. But there's a lot of knowledge behind that. And everybody thinks that they can be an attorney without having gone to law school. I have yet to meet anyone who goes to see a doctor, and if they're ill, they go to the doctor and then they get their second opinion or whatever, and then they say, you know what, doctor, I know better than you. So this is your attorney. If you want another attorney, you're more than welcome to have one, but you will have to hire that attorney. Do you understand?
Yeah.
All right, so we're going to set this for a plea deadline date. Norma, set this for a plea deadline date, the third week in September, please.
If I can speak freely on.
I don't know if your attorney wants you to speak freely, but I'm willing to listen.
Judge.
There's a person that this happened to on this case has made false police reports and everything else. He's not willing to share any of this with the DA.
He's saying that somebody made a false police report on this.
Not to my knowledge, January 25th. You haven't told him anything, right? There was the refusing.
All right, so we're going to come back on September 18th. I'll need an acknowledgement of discovery completed. All right, so we're going to bring you back on September 18th. September 18th will be your plea deadline date. And then next date will be a jury trial date.
That'll work good.
All right, thank you.
Thank you.
Here's the wrap. The court accepted a plea with a deferred finding, set a restitution hearing and sentencing date, and left in place a wide exposure range if conditions aren't met. Key takeaways: 1. Restitution timing can be the deal maker or breaker. 2. Deferred adjudication gives conditional safety but carries serious consequences on breach. And 3. Plea recommendations are just that, recommendations, not guarantees. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.